So hi everybody, thank you for coming to the privacy talk. I'm quite honored to invite Kumar from India. So again, I'm very appreciated to having a call this moment.
Well,
So,
thank you.
Thank you. So he's an expert in the law field. I'm quite honored to exploring with him about the Indian directions related to the data protection this moment. So first of all, I'd like to introduce his profile. Mr. Anand Kumar, as a managing partner of PIER Counsel, has a holistic approach towards innovative and client-centric solutions. He's a widely recognized lawyer with expertise in private equity, venture capital, mergers and acquisitions, fund information, cross-border transactions, intellectual property, and general corporate roles. With over 20 years of experience, he is the go-to person for all legal solutions. In addition to this, he is recognized in the field of academia as well. He is invited by numerous business and law schools in India and enjoys interactions. Furthermore, his love for innovative startups and the budding innovators in IT, social media, gaming, internet bots, AI, AR, VR, e-commerce, financial technologies, digital technologies, mobile application, and the service is evident as he has mentored the founders in the various aspects of strategy and growth. He has assisted various clients to strengthen the strategy from launching a new startups to selling the business. So that's a very great work and experience, Kumar. Thank you for having me this time again.
Well, thank you, Kohei. This was thank you for such kind words and introducing me. It's a pleasure to be here and talking to you. And the topic which we are going to talk to today is very, very interesting topic, not only for India, but globally, I guess. So yes, please go ahead with your questions. I'm ready to answer all of them.
Thank you. So yeah, let me start the first interview topic. You have been quite a so exclusive experience in legal in India. So could you tell us why did you start your law firm and what is any motivations to working on this field?
Sure. So, you know, after starting my, when I started my career, I joined the litigation side of the practice in the courts, and which also, in a sense, helps me today when I'm doing a corporate practice. And I worked in a few large law firms, doing big transactions and, heading teams. So eventually there was a moment came, because I always realized that, I have that entrepreneurial driven spirit and passion, which kind of, helped me to start a firm of my own. While working, I realized that, there were hardly any firm which had, which really represented sort of, many like small businesses. It's very funny. I mean, I'm saying this because lawyers are typically risk averse, right? Because why would I just do work for a small firm? But I realized that's what the inspiration, that let me start something interesting and give quality services to many who don't even get typically in a big firm. And that's how it started. And then, eventually the idea was to probably start and provide the best legal services, and so the firm started in year 2006, actually 2006-7, and that was a time when the venture industry was growing. And we also realized that there was such a lot of velocity in the business expansion and the scale. Everything was happening in a jiffy. So the traditional law firms who were kind of, they had also started dealing with this kind of new tech ecosystem world, and the scale, there was a huge opportunity. The deals were getting really complex, and there was no sort of geographical boundaries anymore. And while I also realized that, I was working on some of the cross-border transactions, so I could see a massive opportunity coming to India, especially from the tech side, since we also worked on all of these Silicon Valley companies and some of the VC funds who were investing in India. So that's where I realized the opportunity, and I started this. Now we have, I would say that we have a completely new programmed lawyers, created a completely new talent who are experts not only in certain niche areas which we cover, which are like VC deals, information technology, IP, corporate M&A, the funding, the whole funding scenario, which comes from the SEBI AIF, the blockchain today. We also have we have been advising companies on their software as a service business. So this is what I'm trying to say, is that there's a wide range of services which now we cover, and yeah, that's how we started. And we have some cutting edge lawyers with us. We are very progressive, we're proactive and futuristic. The team is hardworking, and we're honest to our clients. So things are looking up for us, and yes, that's how the firm started. Also, to add here that let me just add that that how important the role of a lawyer has become so critical in the business, and more so we realize that our importance not just comes from the legal side, but also coming from the business side. Because it is not just transactional, right? Some of our clients, we hold their hands for many years, and that's for some of these guys who we started so small, they have become unicorns today. So it's amazing to see them grow, and we represent both the side. Many a times the financing side, many times we represent the startups and many of the companies. So it's the wide variety of practice which we have been doing now. So yes, that's how it is, Pune. That's how we began early 2006, and it's been almost 2006, 7. It's almost been 20 years now. I mean, yeah, 2007 to 3. It's like 15 years for us in the profession of PIER Counsel. Sorry, my experience is more than 20 years.
Yeah, that's an amazing story. Since you involves the new tech field, that has been a very helpful for the startups. Maybe you have some good relationship with the Japanese companies as well. That could be the start the business in India. So in addition, could you tell us about your company? What is the main work? How do you provide in the service to the clients for India?
Well, as I mentioned that we advise on both the FDI aspects, which is like companies investing who are intending to invest in India, and also ODI, which is the overseas direct investment for those companies which plan to invest out of India. We have clients both sides, investing in form of FDI, and the clients who are based out of India who wants to. So there's an element of cross-border here. As far as our services are concerned, one is the corporate side, one is the litigation, and then there are certain support services. One is like we also provide the intellectual property right. There's a team which is just doing IP. So all in all, we are doing corporate advisory, transactional, the litigation practice, and the intellectual property rights. We also have a team which provides which helps with arbitration and alternate dispute resolution team, which handles the litigation. So overall, I mean, we have also been very actively involved with certain accelerators and angel funds in country where we play a very active role. In fact, some of them, we helped incorporate some of these funds and accelerators. We work with some SEBI AIF funds, which is alternate investment funds. They have a mandate to invest in startups in India. Then, as I said, that one is a very transactional side when we are representing a client who is investing in a company. Then we sort of do all the definitive documents, which includes the shareholders agreement, share subscription agreement. If the money is flowing in as FDI, then we advise, depending on if we are representing a foreign client, then we have to ensure that all the regulations of the RBI is being followed. We do all the filing and basically closing end to end. So that is one side of it. The other, as I told you, is advising on certain IP issues, the domain names. If there is a dispute in the domain name, how do you protect your intellectual property right? Many of our clients, they just use us for, general sort of housekeeping and agreements, drafting for them and advising them legal opinions on an ongoing basis.
Yeah, sounds good. Last time I visited in India is a few years ago. There was a very exciting place that a lot of the young people is to create a new innovation with the technology. Probably for the market perspective, maybe the cross-border has been a very significant opportunities for the foreign companies to start a business in India. So
yeah, that's true. That's true. Actually, also, in fact, incidentally, as we are speaking, last 3 weeks back, the government has allowed the RBI has come with new regulations on ODI, which makes life simple for the Indian founders who want to set up an offshore entity with an Indian subsidiary, which was earlier considered as round tripping. So so this is some very interesting changes that happened there. Plus, India is we have 72,000 startups in this country right now, with touching 100 unicorns. So the interest is obviously global, right? So and also that India, the Indian tech stack is being used in the global superpower IT solutions. So that's the interest, which obviously India is a big market now, with the population, which is young population, and the immigration. So it's truly it's like global, cross-border, and we see a humongous opportunity.
Yeah, absolutely. So to succeed in the business in India, I think we need to understand the market conditions. So my next question is about it's a more kind of compliance part. So you have been working at the law space as well as the data protection in India as well. Then in a recent, maybe it's a very exciting news from the privacy communities that's in India. Bill has been, it's not the past actually. So could you tell us what happens in India and what has been debated in the Indian data protection community in the legal field?
Yeah, sure. So, I was closely working on this aspect with some of senior people, and we were also advising a lot of our clients, and this is a very interesting topic. And now, having said that the government has withdrawn the bill, so data protection becomes very, very important. And I would like to take you into a little bit of history, how it evolved here, in a chronological manner, which put things in perspective. So basically, it began with the IT Act, which was enacted in the year 2000. And that used to cover the confidentiality, privacy, and security for information stored in the computer resource. And eventually, so that's how it was as basic as that. Till in 2011, we realized that we need to have certain data protection rules, because by that time we have so much of IT all around. So and that was supposed to protect the sensitive personal data, which was being collected from individuals and body corporate. So that's how it started. And then eventually, in 2016, there was a very interesting case where the WhatsApp user policy was challenged. So basically, WhatsApp could allowed certain data which was being shared with Facebook, and that's which was being challenged. And the High Court here, they ordered deletion of data of those who had opted out of the service. So there was an option given, and the court also ordered that WhatsApp should not share information which was collected prior to the updated user policy coming to the force, because they had a new user policy. Things moved on. Then we had a very interesting case of right to be forgotten in which two high courts, Gujarat High Court here and Karnataka High Court, they gave a very interesting judgment, which also basically the court said in Karnataka High Court said that which was given in the favor of the petitioner, that his name should be redacted from the cause title and body of the order, and one has right to be forgotten. We moved on. August 2017 is a very important date when Supreme Court recognized right to privacy as a fundamental right, and that was in a landmark decision of, it's called the Justice K.S. Puttaswamy case, and that was, I think, a watershed moment. So then RBI came with a data localization mandate in year 2018, where they in fact they gave a deadline that by October 2018, all the entities they had to comply with the requirement that all the data has to be stored locally, except the one for the foreign leg. And this was with respect to all the data in relation to the to the payment system, which was operated by entity which is licensed and regulated by Reserve Bank of India. So then and then there was the most important and another milestone, I would say, was when Aadhaar was declared constitutional by Supreme Court of India in 2018. So it's a very, I don't know whether you're aware of, it's a very interesting thing, wherein every Indian citizen has a unique 12-digit identification number. So that's something which became very important. Any citizen who wants to avail of services, he has an Aadhaar card, and that is something which was recognized by Supreme Court. And so that was, again, as I said, it was a very, very important milestone. Then we had the draft national e-commerce policy in February 2019. So this is where there was it became very interesting, because they had asked data localization even for the e-commerce companies, but once they got suggestions from various ministries, and there was a little bit of conflict here, so the clarification was released by the government of India that data localization would not be dealt with under the e-commerce policy, as Ministry of Information and Electronics and Information Technology, MEIT, was in the process of introducing the Data Protection Bill. So that's how we come to Data Protection Bill. And eventually, it was decided that we need a special bill to study various, issues in relation to non-personal data. And that's how we came to this whole Data Protection Bill. In year 2017, the government constituted a committee, which was chaired by Justice Sri Krishna, to come up with this, and to release a white paper on data protection, and where basically the government released principles that should form the bedrock of data protection law, and sought comments from various stakeholders. The committee, they released a draft personal data protection bill in 2018, along with the report, which gave the context to the bill. So that is how we reached to the bill. But now we know that that bill has been withdrawn. Probably one of the reasons would be that it had, it's very interesting that, it had almost 88 amendments to a bill which has just 91 sections. So obviously, I don't think there was so many challenges. Though per se, if you ask me, as far as the bill is concerned, which is laid down, the principles, there are certain merits in the bill. So for example, there's the bill talks about no involuntary collection of data. It's more consent based. Then, so if anybody is collecting data, so he has to ensure that the data subject has to provide his or her consent. Then it enables every data subject or a consumer to make an informed choice. So for which, and they also need to know, what is the data is being processed for, amongst other things. So though this was a big deterrent for organization which was actually processing and monetizing data on a regular basis. And so, that's how it is. It basically progressed. And yeah, if you have any questions, then I'll let you know. But what government started looking at is that there is more and more sort of voice in the country that there should be more of data localization. For instance, certain local the biggest companies here in India, including some of the companies, they were arguing that the data should be localized here, and even the government realized that this could be this could ease the ability for the government to tax some of these internet giants. So that's how this whole genesis came, and that was how the data protection bill was drafted. And so yeah, any further questions? Go ahead.
Yeah, recently I just checked one interesting court decision in Delhi court has been decided. Do you know the Telegram is the messaging app? I think there's some of the like in Indian users is been uploading their contents on the Telegram, but those intellectual property is been stored the data in Singapore servers. But in this case, the Telegram is against of the court decisions. The Telegram is been stored the data in Singapore. So in this case, the Singapore law could be applied. They have to protect the data. They are not able to disclose all the information to the Indian subjects. So what are kind of the discussion happens related to the data transfer? That is also the very important topics for the Indian people to use the global services such as the WhatsApp, the same case, or the Instagram or other those global services been stored the data. Even the data is not stored in India, how the court or Indian government decided those kind of decisions.
Yeah, no, that's very interesting, point which you've raised, because the whole thing is so global. It's not just a country specific now. So and that's one of the reasons that as I told you, that there were concerns from various stakeholders while the bill was being drafted. And so the government realized that so while the bill has certain merits, it also has certain demerits, and which maybe there was a wisdom, and that's why they decided to withdraw it, because it has certain prima facie sort of, I would not say demerits, but certain lacunas which needed some sharper sort of thought process. Like for example, the very objective of the bill was that it clearly said that it will not apply to the anonymized data, for example, right? So if there is so while one of the sections, I think to be precise, section 91, it gave a lot of power to the data fiduciary or the data processors to go into, and they could even go and access the non-personal data, and that was a very big concern. So that is something which obviously was was also one of the suggestions which came from various stakeholders and government. I'm sure they have considered this, and because it was very basic against the objective of the Data Protection Act. So this will also do a lot of answers in terms of, like, for example, if I have an account on one of these social media accounts, and the data which I have provided is of a nature of a anonymized data, then that is something which not the bill talks about. So that's something which is not should be the topic of discussion. So that's why so that that sort of things which I was saying, that it needed more clarification. Also, in terms of cross-border sharing of information, I think there were a lot of information that what can be shared and what could not be shared in terms of sensitive personal data and critical personal data. So how do we identify all these? So which can only be processed in India and which can be processed outside by non-Indian entities. So this also needed a lot of clarification, I guess. So that was also maybe this all thing needs to be taken care of while we're drafting the new sort of the bill or act which will come into play. Similarly, one of the very interesting aspects was the processing of children's data. So there was no way under the bill which we could which it could identify that how will you identify the age of a child, and child was defined as age of 18 years. So how will they verify the age of a child? Similarly, these are the things which I would say that which led to withdrawal of the data, and the questions which you asked, I'm sure the government is wary of, and the stakeholders from all sides, they have come up with their reasoning, which they will take care in drafting the new law.
Thank you. Yeah, that's a very complex this moment. I understand. Yeah. So you have been proposed those kind of new draft. So your stance is a little bit close to the startup or new innovations, because innovation is very important in your country. So you propose a very interesting idea that's been like they called in a sandbox, which has been supportive to the startups, the new company, to try the new things within a district and create a new innovation. Could you tell us about the details of your proposal for that?
Yeah, that's right. So, as I said, that there are 72,000 startups here, 100 unicorns. The economy is like we are the fifth largest economy in the world now in terms of GDP, and just fifth United Kingdom, and and the scale of startups, the velocity, the scale which I was talking earlier in my first question. So that also needs, there's so much of various verticals of startup, whether in the fintech space, the health tech, or whether it is like blockchain. So, and it's constantly evolving. So one of the questions was that one of the things which I had proposed while working on this is that they should be allowed to, which otherwise is not possible. That you probably sandboxing is one of the ways in which they can experiment with the data, and there should be certain leeway given to all these new startups and tech companies who can sort of just be on an experimental basis, use the data, and create their startups. So that was taken very well. So I think the RBI is already has mandated certain things, and they have allowed certain many companies in the fintech space to use such data and especially create algos and see and code, etc., and see how they can take the help from the data which is already available. So this also seems to be in a very sort of very initial stage, and I believe that this also going to grow, and government is going to come. There'll be very clear terms on how these new-ish and new startups and founders can work in a sandbox manner.
So that's very good. So to provide the sandbox system, so what kind of the uniqueness in this case? I think in Singapore is been applying it to the sandbox trial this moment. That's been like the government is trying to monitor what kind of the technology could be applied to the compliances of the Singapore privacy rule. So is in India case, is what is the uniqueness? What is the difference from the other jurisdictions? You have any idea of it?
Well, as far as I know that now, what is the way ahead since the bill has been withdrawn? So now a lot of these questions are that how things will pan out, and I wish I had the answer, but I know for sure that government took opinion, and they considered people who had from all stakeholders. As I said, that there were 81, 88, 81 amendments which was being proposed. So I'm sure that is something which emanates from the fact that government has considered the questions from all stakeholders. So now I think what they are planning to do is introducing a new regulations which will be in the domain of telecom, IT, personal data and privacy, social media accountability. And in fact, they have given a term of 2023 by which they will submit the draft for the next data protection framework in India. I'm sure they will have a holistic approach, and they will also consider things like how to allow people to sandbox testing, so that they can come up with the new innovative ideas and thoughts, and it can be scaled and made a big company. So I'm sure they'll take a lot of cues from the erstwhile data protection bill.
So for the new bill, so the Indian government is trying to cooperate or try to resemble this similar regulations, such as the Europe has a very strong data protection regulation, which is the great reference, such as in Brazil, right. That's been one of the countries has been applied to the similar model from Europe, but America has been very different. So what kind of the difference in India is try to approach to the local regulations?
Yeah, so the first idea, I mean, the overall objective is to first to make sure that it removes the old, the current archaic legacy, and of ineffective data protection regime in India. So once that is replaced and comes with a new data protection regime, I think they will consider everything, and we are otherwise we have very closely also looked at GDPR. So all these principles which are rightly set there is also going to, I'm sure, will be forming part of the data protection in India, where there's a lot of reliance will be on consent-based data. A lot of these data subjects, they need to be informed that what the data is being used for, and they have to give consent for such data uses. While we right now the way we have things is again under the IT policy. As I told you, in 2011 we have a data protection rules which covers under the IT Act, which allows privacy, and plus certain judgments which I told you in terms of even the WhatsApp case, where the government said that even when you're coming with your new user policies, you need to ensure that you have to seek consent from your old users also who's not subscribed to the user policy. This shows that the intent of the government is to make sure that people are aware of what data they're sharing, they are giving their consent, and privacy is going to be a hallmark feature in all of them, while still trying to protect the interest of the stakeholders. Like, for example, I told you, unlike the fintech regime where the RBI talked about the data localization in India, right? For the government took cues from the various ministries, and they then, as far as data localization for e-commerce was concerned, they just disallowed that, which otherwise would have been very, very stiff. So I mean, what I'm trying to say is that it's a very fine sort of balancing act which the government will have to do to protect the interest of the data subject, as well as make sure that they don't get into the anonymized data, right? Which is not what the main objective of the data protection bill was. like I told you earlier, that the very objective and Section 91, which gave a lot of power to the data fiduciary and data officers, they can get into any of those. So it's going to be a very, very interesting. Maybe once that post 2023, we should be doing one more round of interview to analyze most of these questions, which will be a very good analysis, I guess.
Yeah, that's interesting. I think the next year is hopefully the news started in India about the data protection. Thank you.
That's right.
So lastly, could you give us any message? Probably the listener have ideas to looking for any opportunities in India. It's very controversial now, but may have some directions. So you have any message to the listeners, probably who are interested in Indian market?
Well, for now, I mean, we have, while we have IP Act, we have data protection rules, and a lot of these things are also contractual. So people, they do get into, every website or every application or every app which is done here, they have their own user policy, privacy policy. So anybody who is doing business or plans to do business here, they need to ensure that they have the right privacy policy, the user policy. They have to, sort of have their own, data manager already. They can define that within their company, who takes care of some of these concerns and complaints, just to make sure that the right corporate governance norm is followed. And most of these things are global, right? Most of like we've seen the same thing in GDPR. So yeah, that's how it should be. I would say that, follow the right corporate governance, make sure that everything is put in front of all the data subjects and users. They know what they're sharing the data for, and the companies, and they should ensure that they have received consent from the data subjects on whatever they are collecting from them.
Thank you. That's very informative. So for us, it's not easy to reach out the information, what's happened, what's going on in India, but this interview is very helpful to understand the status of in India. Again, I appreciate it, Kumar, having this kind of the very precious times. It's a very honor to spend the time with you, this kind of things.
No, same here. And I think part 2 of this interview will be more interesting, because that is the time when we will get to know that, how the camel has sat, because we will have a new act in 2023 with many of these concerns would be taken care of. So I'm sure that, and we need to ensure that we have the best data protection regime in the country, which matches any of the global data protection regime.
Thank you. Yeah, thank you for having again. Then let's keep in touch, keep updates and for the next year.
Okay. Thank you, Koe. Thanks for your time, and thank you for providing this opportunity here. Love to speak more on in the next interview.
Thank you.
Thank you.